Hi, I'm Daniel Findling with Findling Law and thedivorceguy.com. This is part of the Michigan Divorce Education Series, and we're going to discuss prenuptial and postnuptial agreements in contemplation of marriage or contemplation of divorce. When marriage is filled with dysfunction, or if you simply want to properly plan, a prenuptial or postnuptial agreement can help you decide beforehand what you're going to do in the event of divorce. In Michigan, we have two types of agreements. We call these antenuptial agreements that allows parties to plan in the event of divorce how their estate is going to be divided and if there's going to be an award of spousal support. A prenuptial agreement is an agreement made prior to marriage, and a postnuptial agreement, which is an agreement made after the parties married. Now, both of these contractual agreements will help parties resolve issues such as property division, spousal support, retirement accounts, in a contract so that in the event a party files for divorce, that contract can be used as evidence and as a division binding of those issues. But not all issues can be addressed in the context of an antenuptial agreement. For example, custody and parenting time can never be addressed in an antenuptial agreement because circumstances may change and the court has an affirmative duty under MCL 722.23 to make sure that custody is awarded in accordance with the best interest of the children. But what antenuptial agreements can do is resolve disputes regarding property division and spousal support. Now, this notion of in contemplation of marriage or in contemplation of divorce is really set forth in statute. It's an old statute under Michigan compiled laws that provides that a contract relating to property made between spouses, in quotation marks here, in contemplation of marriage is enforceable. However, it doesn't say in contemplation of divorce. And the notion between a contemplation of marriage and in contemplation of divorce, and that distinction is important because of public policy considerations. In this slide, I'm quoting Michigan Law Review article from 1943 that discusses this notion of public policy. Prenuptial agreements are generally favored because they tend to promote domestic peace and happiness. However, they're void if they offend public policy. And because postnuptial agreements are entered into after the parties are married, in 1943 they were void because they offended and violated this public policy of promoting marriage. So we stated this problem with prenuptial agreements and postnuptial agreements. Contemplation of marriage, prenuptial agreements are enforceable because they are entered into in contemplation of marriage, whereas a postnuptial agreements are not enforceable because they're in contemplation of divorce. I'm going to divorce you unless you sign this agreement. However, there is a workaround. And the workaround really isn't that complicated. For a postnuptial agreements to be enforceable, attorneys will first file for divorce, then the parties will sign the postnuptial agreement, and then they'll dismiss the divorce, oftentimes in the same day. We draft the agreement. When the agreement's done, we'll file for divorce, and either later that day or the next day we'll dismiss the divorce, and now the postnuptial agreement is enforceable because in contemplation of dismissing the divorce, remaining married, in contemplation of marriage, the workaround postnuptial agreements in Michigan are enforceable. So there are two cases that most practitioners should know, Rinvelt versus Rinvelt, which is the seminal prenuptial agreement case, and Lenz versus Lenz, which is the seminal postnuptial agreement case, describing how and why they're enforceable. Now, there are additional requirements that every antenuptial agreement has to have, whether it's a prenuptial or postnuptial agreement. It must be voluntarily entered into. You cannot have fraud, duress, mistake, or non-disclosure of a material fact. Oftentimes we'll see an Exhibit A and Exhibit B setting forth all of the parties' assets and liabilities when they entered into the agreement. The reason those exhibits are there is to demonstrate the voluntariness. They knew everything, what they were bargaining into or giving up at the time, if anything. It can't be unconscionable. Did the parties have equal bargaining power? And what is the reasonableness of this agreement? And finally, are there changed circumstances? And we're going to discuss the Allard case in the next slide, but changed circumstances is also a requirement, and that may limit enforcement of a postnuptial or prenuptial agreement. The big rule, though, and the key learning here is that for the most part, these agreements are enforceable in Michigan. The Allard problem comes from the case Allard versus Allard, which is cited on this slide. In the Allard case, you had an agreement that was unconscionable to enforce. However, the court took a unique approach in determining that they weren't going to enforce this agreement. What the court did is said, you know what, there's this statute, 552.23, we call this an invasion statute, and what that statute provides is that when determining a property division, a court must take into consideration if the nature and the extent of the estate, that is, who's getting what, is so disproportionate that it's going to leave one party with virtually nothing. And in those instances, you can invade separate property. The Michigan Court of Appeals in Allard said, you know what, you cannot waive that requirement because the statute says, and the legislature requires only a judge to do that. Now, this created a big problem when it came to antenuptial agreements because practitioners thought that's the end of them. After all, you write an agreement saying who's going to get what in the event of divorce, and a court can just come along and say, nope, we're going to invade separate property. I don't care what you agreed to. However, over time, the Allard problem has not been that big of a problem. It really only applies in cases where the agreement is so unconscionable to enforce, and lawyers, especially seasoned lawyers, have workarounds that are properly written can really protect you against the Allard problem. So the key learning is it's important to have somebody skilled in writing or reviewing your pre or postnuptial agreement to avoid problems such as Allard that we discussed here. Hopefully I've been able to provide you a better understanding of antenuptial agreements in Michigan, prenuptial agreements, and postnuptial agreements. While the distinction between in contemplation of marriage or in contemplation of divorce may be academic with workarounds, it's important to understand that a prenuptial agreement or a postnuptial agreement really needs to be properly written and reviewed by a seasoned lawyer to be enforceable, to ensure that it's voluntary, that it's not unconscionable, that we dealt with the Allard problem, and so forth. On the divorceguide.com, you can watch more videos, part of the Michigan Divorce Education Series, on divorce and related topics. If you have additional questions or comments, feel comfortable calling me at 248-399-3300. We have a toll-free number, 877-YOUR-FIRM. Let it be my privilege to help you. We're here to help.